Welcome to everyone who's joining us. I think we're just taking another minute to make sure everyone from the waiting room gets into the presentations. We'll get started in just a moment. All right, with it being 9:02, I think we'll get started. Good morning, everyone. Welcome to the 2023 New England Human Resources Legislative Update, hosted by Verrill and Main Street Solutions. My name is Liz Johnston. I'm an employment and labor attorney at Verrill, and I'm joined by my colleagues Tawny Alvarez, a partner in Verrill's Employment and Labor Group, and Peter Gore, a senior government relations specialist with Main Street Solutions. We're glad that you could be here with us this morning. It's been a very busy session and we have a very full program for you. So I'll start out with a few housekeeping items and then we will get started. So the presentation this morning will be recorded and the slides will be available to you and emailed to you after the session. Please note we also have everybody's microphones on mute, but we do welcome your questions throughout the session. If you do have questions, please feel free to drop them into the Q&A feature and we will try to get to those as soon as we can, either during the presentation or at the end. With that, we'll go to the next slide. So we're going to start out today with a brief overview and sort of a first-hand account of the latest legislative session from Peter Gore. Then we'll get started discussing some of the new legislation that's passed in Maine, as well as some that continues pending. For the next session, we will touch on updates in New Hampshire, Connecticut, and Vermont. And lastly, we hope to have some time for questions at the end as well. So with that, I will turn it over to Peter.
Thank you, Liz, and good morning, everyone. Thanks for being here. I think we have a good presentation this morning, one that you'll find very interesting. I took a quick pass through our participants this morning. There are some folks who are familiar with the legislature and the legislative process, some folks that I've worked with in the past. So some of this may sound familiar to you all, but it was a very, very busy legislative session. For some of us, it was a session that felt like it was never going to end because we were still going at the end of July. We had over 2,300 bill titles submitted this session. It was a very difficult session for the business community with a lot of legislation in the Labor and Housing Committee in particular, but also in the Insurance and Financial Services Committee as well. The bill and Judiciary, the bills ranged from sort of nuisance value to bills that will add complexity and cost to every business in this state bottom line. The process was a difficult one. There is very much a holdover from the pandemic legislature in which it is hard to keep a handle on what's happening in the various committees. Amendments came in at the last minute, often without the business community representatives really or anybody in the room who were following the legislation an opportunity to review them in advance. Oftentimes, important bills did not get enough scrutiny by the committees, but they were enacted or sent forth anyway. All in all, it was a difficult process, and I wish I could frame it up in a different way, but I really can't. I hope the legislature going forward will have a more transparent process and one that involves the stakeholders and participants, including the general public at large, more actively. That did not happen this session, and it's certainly a conversation amongst those of us who spend time there, one that we've had and expressed concern over. Going forward this morning, we'll touch on a variety of different bills that impact the workplace that are HR related. I hope you'll find it helpful. I hope you will ask questions. And Liz, I'm not sure I have a lot more to say other than that. We can just go forward.
Sounds great. So we'll jump to the next slide, please. All right, so diving into some of Maine's new laws, we'll start with LD 12. LD 12 was an expansion of the Maine severance pay law, and it expands the organizations that are covered by it. So as a brief summary, if you're not already familiar, the current, or at this point, the old severance pay law required that industrial and commercial facilities that have a closure, mass layoff, or relocation adhere to certain severance pay obligations, which is essentially to pay laid off employees a week of pay for every year that the employee has been with the company and provide requisite notice of the layoff or closure. But that only applies when the employee has been with the company for 3 years. So the amended law removes that reference to industrial or commercial facilities in the language in the statute. So it applies to facilities and employers outside those industries as well. One of the, I think, facilitating reasons for this is that, as businesses have changed and the makeup of the workforce in Maine, the intent was to have it cover more than just the industrial commercial facilities that were typically comprising a larger portion of the workforce in the past. Another small change in the statute is that there's no longer an exception for consolidating a business. So a mass layoff related to that would be subject to the severance law payout. But there are a few things that are staying the same about the severance pay law. First, it's only going to apply to facilities with 100 or more people employed at them. And the other big piece is that employees still need to be employed for 3 years before being eligible for the severance pay. The initial bill had included a proposal to remove that requirement and have it apply to the workforce more broadly, but that piece did not make it into the final version, and the DOL actually changed their position on including that requirement. In addition, what constitutes a mass layoff or a trigger for the severance pay law will stay the same, except for that business consolidation exception that I mentioned. So if your organization is 100 or more employees, or your facility, and you are facing a large layoff or a closure, you need to be thinking about your obligations under the severance pay law when you did not necessarily have to in the past if you weren't an industrial or commercial entity. Peter, anything? Yeah.
Yeah, the only thing, a couple of things I would add was we strenuously objected to the elimination of the 3-year requirement. Maine's already an outlier, and we are one of the few states that actually has a severance pay law on the books. It's been around since the 1960s, and in some form even earlier. And the original intent was mass closures at a place like a paper mill, not just necessarily to just impact the employees, but also these were often located in communities that were rural and isolated, and the economic impact was relatively severe on those communities. That was the thought process behind the original severance pay law. I think for most folks on this call, this change really won't affect you unless you are a non-for-profit or nonprofit. The department was very clear that's who they were attempting to get to. They had a number of closings that involved nursing homes and skilled nursing facilities they felt should have been covered by the severance pay law, and they were not. That's why they struck the industrial or commercial language in the old law. And going forward, it basically encompasses any employer in this state that has more than 100 employees for 12 months at any single facility.
I have a question from the audience. Does the employer have to have 100 or more employees in Maine in order to be subject to this law?
So the answer is technically yes, because it applies to facilities with 100 or more employees. So having a more scattered workforce across the state would not necessarily trigger the severance pay requirements. Likewise, if they were out of Maine.
Yeah, if they have 50 here and it's 75, 100 or 75 there, just because it's more than 100, that doesn't necessarily mean it would happen. If they had all 125 employees at a single site, and that's the important part, then they would be required to comply.
All right, so the next new law we want to talk about is the Act to Protect Employee Freedom of Speech, LD 1756. This is a big one that I'm sure a lot of you might have heard about in the news or through the grapevine. This new law provides that employers are prohibited from taking adverse action against employees who decline to attend or participate in an employer-sponsored meeting or decline to receive or listen to a communication from an employer if the meeting or communication is to communicate the opinion of the employer about religious or political matters. So this law was intended to prevent employers from holding like mandatory employer-sponsored meetings during union organizing campaigns. In the past couple of years, we've seen and we've talked about in our past presentations at Verrill, the workforce has been very active in terms of labor issues and workforce unionizing, especially in industries that aren't typically where we see unions going into the workplace. So it's not surprising that we're seeing the efforts to increase employee protections there. But the new law is much broader on its face than that goal would appear to need. So political matters, for example, has a huge definition. It's matters relating to elections for political office, political parties, proposals to change legislation, the decision to join or support a political party or political civic community or labor organization. Religious matters is also fairly broad. Any matter related to a religious belief, affiliation, practice. So we get that language about supporting labor organizations in there. But again, the way this is worded is very open to interpretation and broad as to a whole host of topics about, that can be encompassed in an employer meeting and communication. Just as an example, one of the areas we'll be looking at is employer DEI efforts, diversity, equity, and inclusion. Those issues have become very politicized in the past few years. So, one issue potentially is whether an employer is going to be able to hold those types of meetings or trainings in a mandatory way, or whether an employee might be able to allege that it's, potentially related to a political or religious purpose, and thus in violation of the statute. So going forward, employers are going to need to be careful and really think about what their mandatory meetings and communications relate to, and really keep an eye out for how this law parses out in practice and litigation as well.
So, Liz, this is a fairly highly charged political piece of legislation that came in fairly late in the session. I was representing the chamber and worked with a number of other business associations who strongly oppose this bill. And I don't want to get too far out over my skis on this because I'm not the attorney and you and Tawny are. But in addition to the problems that Liz lays out, this bill it does more than sort of. It impedes protections that are found in the National Labor Relations Act. For employers in particular. The idea behind this bill is it puts the thumb on the scale of the union organizer in the workplace by preventing the employer from having mandatory meetings, which they're entitled to under the NLRA, to educate employees about unions. And they can't be coerced and they can't be threatened to attend those meetings, but they can be paid to attend them as if work were taking place. And political matters absolutely encompasses, or the definition in the law, a labor organization. We vigorously opposed this bill. We sent repeated letters asking the governor to veto the bill. We warned the administration and the labor committee that employers were likely to encounter problems around meetings like DEI education, LGBTQ meetings and education, that people would say those are political, I'm not going to attend. And while the employer could still hold those meetings, it's possible that people just wouldn't show up, or nobody would show up because it would align with political or even religious beliefs. I know they were concerned about that, and for some reason they decided to go forward with this bill anyway. Here's what's important. Connecticut passed this bill in 2022, and in 2023, the Connecticut Business Association, which is their version of the chamber, and the U.S. Chamber filed suit alleging the constitutional violation around the NLRA. And recently, a federal judge ruled against the state when they requested a dismissal of the employer's case. People are waiting to see what happens in Connecticut because it has implications for the Maine law. And I'll let Tawny and Liz take over and talk a little bit about this. This is a very important issue, and undoubtedly it's going to come up after October when this becomes law in some workplace in some fashion.
Yeah, thanks, Peter. So in the Connecticut bill has similar language to what we're seeing here in Maine. The employer coalition in Connecticut sued, not only arguing that there were issues as it relates to the National Labor Relations Act, which people may recall is the overarching federal regulation, so it preempts state law, but also arguing that it violates the First and 14th Amendment rights by discriminating against employer viewpoints on political matters and by chilling and prohibiting employer speech. Now, you know, as Peter mentioned, the state filed a motion to dismiss. The court denied the motion to dismiss, which means that the matter will move forward. Any of you who have worked with us in the past, unfortunately, knows justice and the legal system does not move swiftly, but it is our hope that we'll have a better understanding as to where Connecticut and that legislation falls kind of within the next 12 to 24 months. This is not, however, the first time that this type of legislation has been attempted. Maine actually is the third state to enact this type of legislation. California, unsurprisingly, was the first, Connecticut the second, Maine the third. As to the California law, in 2008, the United States Chamber of Commerce financed a successful challenge to the California law that had regulated employer communications with employees. Now, it's interesting because the Maine statute goes further than the California statute did. The California statute didn't ban mandatory meetings. It really only regulated communications. The reason why that's important is because the United States Chamber of Commerce was successful in its suit to challenge the California law. And in fact, the Supreme Court struck down the law in a 7-2 opinion, concluding that the California law was preempted by federal law, specifically the National Labor Relations Act. So despite that ruling, Maine's law goes further by banning mandatory meetings. So I think we, as Liz said, we do need to be mindful. The law is on the books as of October 25th. It will be applicable to employers. So I think it's important that employers be mindful that there would be risk in moving forward with mandatory meetings that arguably could fall within religious matters or political matters, but simultaneously be aware that there are going to be some pretty significant challenges to this legislation. As we've discussed in the past, we are always happy, you know, to help you argue if this is a cause that you feel strongly about, that you would like to kind of be a test case for. We are always happy to serve in that role in an attempt to challenge these type of laws. So I think that's kind of a good understanding of the background as to this law. Peter and Liz, anything additional to add from a background standpoint there?
No, not for me. That was, I think, super helpful. Yeah, especially a lot of these, you know, laws it's helpful to have that context in terms of what other states are doing and where this came from to help understand where it might go as well. So with that, we'll jump to the next one. Next slide. Okay, so the next one we want to talk about is an increase on the damages limits under the Maine for violations of the Maine Human Rights Act. So if you're not familiar with it already, the Maine Human Rights Act damages for a plaintiff alleging a violation are limited by Maine law. So there's caps on the damages available, and it's based on the number of employees that an organization has. So as you'll see on the slide, we sort of show the prior caps and the new caps that were enacted as part of this legislation. It doubles for the smallest employers, triples and nearly doubles for the biggest employers. Honestly, this LD is a big win for the plaintiffs bar. It's been a long time since the damage limits were raised, and one of the justifications for this that we saw was, look at how inflation has changed and how the value of a dollar has changed. So it makes sense to raise these caps. That said, as a result, we do expect to see potentially more cases being pursued past the commission process, because there's a significantly greater chunk of money and potential reward for plaintiffs' attorneys for pursuing those cases if they're successful. And it may be more difficult to put settlement values on cases and reach settlements because there's an elevated monetary risk if the case were to be successful at trial. One thing that hasn't changed is that we do still look backward in terms of figuring out an employer's size. So to figure out the size that your organization falls into, you look at the current or preceding year in relation to when the discrimination occurred. But the new cap will likely still apply to matters that are pursued after the enactment date or the effective date of the new statute. So the elevated risk here just makes it more important than ever that employees and managers are being trained on anti-discrimination and anti-harassment policies and procedures. That way we mitigate the issues that could lead to litigation that would potentially incur these caps. And as another practical step, it's worth checking with your insurance companies and your insurance policies to make sure that you have coverage to meet these increases on damages limits.
I really can't add a whole lot more. There was no stopping this bill because these increases, these caps hadn't been increased in 20 years, and it was the speaker's bill. There was nothing that was going to be done. The only thing I would add is, in addition to increased likelihood of litigation and increased settlement values, you can look to your EPLI to increase as well. Employers will have to not only increase the amount of coverage they get, but they're going to pay more for it.
Liz, one of the questions that we got, if there's a case that's already been submitted for an employee who has already left the company, would they be eligible for the increased cap, or would the prior cap apply, since that is what was in place when the event allegedly took place?
Yeah, so that's a great question. So if the complaint has already been filed in court before the new caps take effect, the prior caps will likely apply. If the complaint is not filed yet, like let's say we're only in the Maine Human Rights Commission process, but there might be, a complaint filed in Superior Court later, that complaint needs to be filed in Superior Court after the effective date. So Maine law has restrictions on retroactivity of these types of statutes, or statutes generally. So if the complaint is already filed in Superior Court and that's already moving forward, then these would not apply retroactively.
Perfect. Thanks, Liz.
Yeah. All right, let's go to the next slide. So an act to amend the Maine equal pay law. So this LD 1703 adds race as a protected classification under the Maine Equal Pay Act. The current Equal Pay Act provides protection only for sex-based pay inequities, but again, this adds race and prohibits employers from paying employees in the same establishment of different races rates that are different from one another when they're doing comparable work and they're in comparable positions when we look at the skill, effort, and responsibility of those positions. So, one of the things that you may be thinking is that, race discrimination is already prohibited under the Maine Human Rights Act. And you are exactly right. That is true. It is illegal to discriminate against an employee on the basis of race already, including in terms of compensation. But this amendment provides much more explicit protections against race discrimination in terms of equal pay. And the Equal Pay Act actually has much broader implications in a way because of the way case law currently stands. So there was a case last year that held that the Equal Pay Act in Maine applies to unintentional discrimination in pay discrepancies. So the simple fact that two employees of different sexes or now different races, the simple fact that they're paid differently for the same job, the same, doing the same work, even if it's not intentional, it's still a violation of the law. The case that was decided involved a female psychologist who was paid less in wages than her male counterparts. It wasn't, determined to be intentional by the employer. In one case, one of the male psychologists had negotiated his own salary when he started. But just as a matter of fact that they were being paid differently, the court found a violation of the equal pay law for that employer. So the case has been appealed. We are still waiting on a decision from the First Circuit to see if that decision will be upheld or overturned. But until then, and especially if it is affirmed, it's super important for employers to be making sure that they're auditing their payroll and keeping track of how pay decisions are made, how compensation decisions are made, and again, auditing to make sure that there's not discrepancies that are developing over time that might form the basis for an allegation that there's been a violation of the Equal Pay Act. And also, one thing we learned from that case is to be careful in hiring and having employees negotiate higher salaries that put them at an inequity compared to people doing similar jobs who are of a different sex and a different race, because that type of unintentional fair market value determination can still be a violation here.
Yeah, I think, the only thing to add here is just, in comparison to other state laws and federal law, be aware that comparable work and comparable requirements is a lesser standard than jobs that require that have the same title, the same, Maine's law as to equal pay is broader and I guess looser when we're talking about comparators than many other states. So just keep that in mind. But that's all I have from that standpoint.
Perfect, thanks. Next, we have an act to amend the Maine Human Rights Act regarding right to sue letters. So we'll just do a quick update on this one. So if you're not familiar with this process, a right to sue letter is issued by the Maine Human Rights Commission after an employee or complainant participates in the Maine Human Rights Commission investigation process. And getting that letter allows them to move forward with litigation in Superior Court and be eligible for damages as a reward. So the new statute sort of revises the 180-day requirement, which I know many of you are familiar with, but it provides that the commission shall issue the right to sue letter on the request of a complainant after 180 days, but it also provides a process for issuing one earlier than 180 days. The law says that if somebody requests a right to sue letter before that 180 days is up, it can be granted if there is one, good cause, and two, if it's unlikely that the commission is going to complete their investigation during the 180-day period. So it's not clear what necessarily constitutes good cause for that requirement, but for the second one, it is likely that many cases might not be able to be completed in the 180-day period, given the backlog that we've seen going on in the commission right now. One thing that was initially proposed was the commission could automatically issue right to sue letters after 180 days, but that did not make it into the final version. The complainant still needs to request it. And another change that was made was an addition of an explicit provision that says you need to have a right to sue letter in hand in order to pursue your civil action. There's been a few cases in the past couple of years where the federal court in Maine has allowed plaintiffs to move forward with their litigation despite not having that right to sue letter in hand, which really seems to contradict that requirement that individuals exhaust their administrative remedies through the commission before moving to Superior Court. So it's a technical clarification, but I think an important one in the process.
So this is my one win of the entire session. This is the chamber. This was my client, the Maine State Chamber's legislation. It was put in at the request of their HR committee. It had sort of a tortured process, like many bills, in the Judiciary Committee. The part about the Maine Human Rights Commission being able to automatically grant the letter, in other words, dismissing their case, the committee was not particularly comfortable with. But they did go along with the other two parts. And in particular, we were looking to make sure that the federal courts didn't allow people to go forward in exactly as Liz said, in contradiction to the statute. So at any rate, that was really, it wouldn't have happened without Representative Steve Moriarty, Matt Moon, and Senator Ann Carney. They were very helpful in helping me get this to the governor's desk. One interesting point, some of you may or may not be aware, but the executive director of the Maine Human Rights Commission, Amy Sneerson, is leaving, or she's already left. So that commission will be in the process of finding a new ED.
Perfect. Thanks, Peter. Tawny, did you have anything to add on that one?
No, let's jump to that next slide. So the next one we want to talk about is individual liability for sexual harassment and assault. It's a workers' compensation amendment, and it's LD 53, and it goes into effect October 25th. But what this does is it unfortunately amends the Workers' Comp Act and provides individual liability for sexual harassment, sexual assault, or an intentional tort related to sexual harassment or sexual assault. And some of you may be scratching your head saying, Tawny, why did you say unfortunately? The way that things are currently set up, workers' compensation is the only avenue, or prior to this bill, the way the system was set up is that the workers' compensation route was the only way that an employee could recover for damages related to, the workers' compensation route or the Maine Human Rights Act are the only ways that you could kind of move forward for sexual harassment, sex assault, or intentional tort, right? Moving forward, if there is a claim for workers' compensation damages, it would now appear, based off of the language of the statute, that supervisors, officers, directors, employees, anyone who is accused of that sexual harassment can be brought in as a party. They would have individualized liability. And while they don't have individualized liability under the Maine Human Rights Act, because the Maine Human Rights Act very specifically says employer, not individuals, right? You could sue supervisors or employees for different torts, intentional infliction of emotional distress, battery, assault. So all these tort avenues that otherwise were foreclosed because the Workers' Compensation Act said, hey, when something happens at work, you have these two kind of areas where you can get remediation, either workers' compensation or the Maine Human Rights Act has now been expanded so that any individual who they themselves are being accused of harassment, sexual harassment, sexual assault, can now also be named as a party with tort causes of action being brought against them. So it's going to increase the number of defendants that we see. It has some interesting effects on employers' EPLI coverage as to whether or not your coverage covers claims for tortious conduct, which previously hadn't been permissible under the statute. I want to turn it over to Peter because this was something that, he worked closely on and fought hard for, that we just unfortunately were unsuccessful in keeping off the books.
Thanks, Tawny. Yeah, here's the problem. This is the first bill that Maine has enacted that pierces what's known as exclusive remedy. And those of you who are HR professionals on this call know that workers' comp, in the event of a workplace injury, the worker is entitled to certain swift but time-limited benefits. At the same time, the employer is held is not liable for the fault of that resulted in the injury, the compensable injury. That's known as exclusive remedy, and employers couldn't be sued in addition to providing comp. Now, under this, and albeit it is a narrow exception, it's an exception nonetheless. Unfortunately, about 39 other states already had some limited exception to exclusive remedy in their comp laws, and that worked against us in committee. Furthermore, the sponsor of the bill, who was also a plaintiff attorney, was able to argue that this didn't impact employers, only the people that were guilty of the egregious conduct. And while we agreed that it was egregious conduct, we also said, if the employer is the officer or the supervisor, then or the owner of the company, and then the company itself could end up being wrapped into the litigation. We were very concerned. We remain very concerned. The actual impact of this bill is not clear. Here's the problem. Now that they've done it one time around sexual harassment or assault, our concern is they're going to try and do it with something else next. And you cannot have, we have a no-fault system, regardless of how the injury occurs, whether it's the employee's fault or the employer's fault. It doesn't matter. They're compensated. But this was an attempt to get around the limitations of benefits under the Comp Act and the caps found in the Maine Human Rights Act. And that's what this was really about.
Okay, let's unfortunately jump to the next slide, because we do have a lot. I mean, I feel like we could spend a lot more time kind of talking about how unfortunate that is, but let's move on to tips.
Sure. So I know we all want to get to paid family medical leave as well. So I'm going to just run through a couple of these next LDs. So this next one I want to talk about relates to a sort of a nuance in Maine wage and hour law that's applicable to your salary exempt employees. Currently under the law, salary exempt employees are exempted from a few of the other wage and hour statutes, including the requirement to pay employees every 16 days, and the requirement to have a regular payday and to keep accurate wage and hour records. The statutes were amended to clarify that employers may still create a separate pay interval for salary exempt. It doesn't have to be 16 days, but it does need to be a regular pay interval. The employee needs to be given notice of it, and the employer does need to keep accurate records of dates and wages paid. So to the extent that you need to make any revisions to your salary exempt payroll practices, that's a good one to know about. The next one's the expansion of permissible tip pools. So for anybody in the hospitality industry or who has employees that collect tips, this is an update on what kind of tip pooling is appropriate and permissible. Under Maine's current law, only service workers or front of house, those customary front of house type workers can participate in a tip pool, even if everybody agrees and wants to share with others, including their back of house staff. And we've seen a big increase in I'm sure you have too, in tipping, especially at non-restaurant type industries where everybody's working together, but only those front of house people can participate in a pool. Federal law was amended a few years ago to change that and provide that back of house dishwashers and so on can participate in the pool, and Maine law contradicted that until this session, where it's now coming back into alignment. So tip pooling is permissible with employees at the organization, regardless of whether they're front or back, but managers and owners are still not allowed to participate. So keep that in mind. The other piece of this is employers can't take the tip credit if back of house employees are included. So we'll jump to the next slide. All right, a couple more here. So there's a new law or provision enacted that gives a state right of action to enforce anti-retaliation aspects of Title 26. So basically, Title 26 includes all of our wage and hour laws, rest break laws, earned paid leave, things like that. Basically, just a ton of the employment practices laws. And the new law provides that the DOL or the AG can pursue an action against an employer who retaliates or attempts to retaliate against an employee who is asserting rights underneath Title 26. So there's a little bit of overlap here with the whistleblower law. It's already, employers are already prohibited from retaliating against employees who raise concerns about illegal activity in the workplace, but this provides that the DOL or AG can assess a fine against the employer for retaliating as well.
Hey, Liz, can I just add one thing on that one? So this was a Department of Labor's bill, and they were pretty upfront in saying, and it's true, in the Workplace Protection Act in Title 26, there are a variety of definitions of what constitutes retaliation, and their real intent was to come up with a common definition of retaliation that applied across the entire WPA. So in some ways it simplifies it, but I'll tell you the good news is in testimony, the head of the Wage and Hour Division indicated that there is very little evidence in Maine of employer retaliation against employees for protections that are found in the Workplace Protection Act, Chapter 7 and 26. So that was good news.
Definitely. The last one here I wanted to flag for you all is some updates to the Workers' Compensation Act. I don't want to dive too deep into these, but it's worth being aware that there have been a few amendments to sort of more technical aspects of the Workers' Compensation Act, including changes to the process of independent contractor determinations. The amendments also do add a clarification that insurers can seek reimbursement from an employer if the employer fails to provide information that causes the insurer to not file forms on time. So it's an added incentive to make sure that if you are facing a workers' compensation claim, to work carefully with your insurer in a timely manner to make sure that things are being filed on time. There also are some sections establishing provisions about fronting companies that would apply to self-insured employers operating in other states. So with that, I think we will dive into paid family. Carried over laws next.
Yeah, and I'll just let Peter do it. I mean, the important thing here is everyone needs to understand how much there simply is that's been carried over, so that this is at top of mind, but I'll let Peter kind of highlight in his mind where we need to be focusing our attention.
So everything you see under the title carryover are all bills that were actually enacted in both the House and the Senate. And the only reason they did not go into law was because, well, with the exception of 1896, there wasn't enough money to fund them. And I mean, I guess there's a few that they're waiting on. Let me just highlight a couple. 1190, ensure a fair work week by requiring notice. That bill will require you to pay 2 hours of pay to any employee whose schedule changes through what they would say is no fault of their own, but it could also be through no fault of the employer. So you may have someone that gets called in and then you send them home and you'd still have to pay them 2 hours regardless, similar to a New Hampshire law that's currently in place. LD 513, the overtime bill, changes the threshold, the monetary threshold that divides a salary employee and an hourly employee, particularly for the purposes of overtime. This is the fourth legislature that's tried to adjust this. If this legislature had their way, that financial marker would be north of $70,000 as the bill currently stands. There are a number of bills in here. The non-compete bill would completely outlaw non-compete clauses in Maine. You have the surveillance bill. The livable wage bill would increase the minimum wage to $15 an hour this year. Because it was carried over, now that won't happen, but who knows what they'll do next session. 1896 would index workers' comp benefits. And adding a cost of living adjustment back into comp would add one of the biggest cost drivers under the old system that we had in place. It was eliminated in the 1992 reforms, and it also happens to be retroactive. And then under next session, the bill you really want to watch is 324 to prevent the wrongful firing of Maine workers. That attempts to end employment at will in Maine and put in place a step process for termination of any worker in any employment in any business of any size in Maine.
And with that, we are going to jump into, I think, what a lot of people have been waiting for, which is paid family medical leave. For anyone who joined Peter and I earlier this year for the chamber event, when we started talking about legislative updates and included discussion on the Paid Family Medical Leave Act, you're going to see some differences in what the original proposed legislation was and what finally was enacted. We're going to highlight things that are different, as well as highlight some of the kind of more concerning things that people need to have at top of mind. So first, kind of to understand, is the timeline. The rulemaking process will begin in January of next year. The rules related to kind of how all of this is going to be implemented must be adopted by January 1st of 2025. And it's January 1st of 2025 that contributions are going to need to begin to be made. And we're going to talk about what those contributions are. And then the law itself will go into effect May 1st of 2026. So that's when benefits will begin and individuals will be eligible to take paid family medical leave. As to eligibility, for those of you who currently have to comply with Maine's Unpaid Family Medical Leave Act, because you have 15 or more employees, or those who need to comply with the federal Family Medical Leave Act with 50 or more employees, you're going to see similarities in what those requirements are as to who's eligible to take sick leave for what reasons. So to bond with a child, whether or not it's through birth, adoption, placement, foster care, to care for the employee's own serious health condition or the serious health condition of a family member. Qualifying exigencies related to service members, to care for covered service members. One of the additions, though, and the expansions is to take safe leave, and safe leave puts almost teeth into Maine's Domestic Leave Protection Act. So it permits individuals to take family leave if they are obtaining medical care, psychological care as a result of being the victim of violence, assault, sexual assault, or stalking. So that is one of the expansions. Also, the definition of family member is expanded. It includes child, parent, spouse, grandparent, grandchild, sibling, and that it also includes in-family member, what's known as a covered individual or designated covered individual. And this definition changed and evolved between the first draft of the bill and what was ultimately passed to include a process in which an employee can designate one person each year who is an individual with whom they have a significant personal bond that's like a family relationship, regardless of biological or legal relationship. So family member is more expansive than under federal law or even the current state law. And then we have kind of the eligibility or reasons you can take the leave. Additionally, you may recall that in the first draft of this bill, what the benefit year was defined as was based off of a calendar year, which could result in an individual being allowed to take up to 24 weeks of leave in a year, because it wasn't based off of a rolling year, but instead based off of a calendar year. Thankfully, the final bill was amended so that a benefit year is defined as a 12-month period beginning on the first day of the calendar week that immediately precedes when the leave begins, as opposed to the first day of the calendar year, which would have allowed employees to stack their leave. Peter, as it relates to just kind of timeline, reasons you're permitted to take leave, or those definitions, anything to add there before we get into some of the other meat of the bill?
I mean, I think it's important to point out that a couple of things, and I just saw the question in the chat. This applies to all Maine employers, regardless of size. Regardless of size, the unpaid leave is 15 or more, state law 50 or more, federal law. This is all employee or employers, regardless of size. It impacts all Maine employees, whether you are full-time, part-time, seasonal, if you're a student, if you're a sole proprietor, or an independent contractor, you qualify for paid family medical leave, providing you meet the earnings requirement that is found in the law, which is minimal, quite frankly. So the answer to the question is, does this include student workers? It absolutely does, and it includes all Maine employers, regardless of size.
The only exception would be for federal government. So if someone's listening, they're an employee of the federal government, then they are excluded here. We do have another question that's going to come up in the next. Let's go to the next slide as we kind of dig into some more of this. So how much leave? The statute itself provides that a covered individual can take 12 weeks of family leave or 12 weeks of medical leave. So medical leave would be related to the individual employee's own serious health condition. And then 12 weeks of family leave would be for all the other reasons: to care for a family member with a serious health condition, exigency leave, covered service member leave, kind of all of those different ones. Now, previously, the language in the proposed statute was stuff that it was such that it was unclear as to whether or not you could stack those leaves as well. In the current language, however, you get only 12 weeks per benefit year. So it's not that you can add on unless it's supported by documentation from a healthcare provider. So specifically, the language is, this subsection does not prevent a covered individual from taking medical leave that's immediately followed by family leave when the medical leave is taken during pregnancy or recovery from childbirth and is supported by documentation from a healthcare provider. So if there's healthcare provider documentation that medical leave was necessary in addition to the family leave, then those arguably then could be stacked in the same application year, which I don't want to say conflicts, but under Section C, it says you can't take more than 12 weeks in the aggregate of the two, but then it indicates that you are not prevented. So I think we're going to have to get some clarity in the Department of Labor rules as to what's meant by those, how those two subsections are read concurrently with each other. Benefits during leave. This goes to one of the questions that we have right now, which is kind of related to collective bargaining agreements or additional rights. While an individual is on paid family medical leave, you cannot affect the employee's rights to accrue vacation time, sick time, bonuses, advancement, seniority, length of service credit, or other employment benefits or services. It does not obviate an employer's obligations to comply with an employer policy, law, or collective bargaining agreement that provides for rights to leave that are greater than or additional to those provided in the subchapter. But if they are less than, then the obligations set forth in this rule would be applicable. Additionally, in any ways that curtails the right, it does not curtail rights or remedies that an employee has under a collective bargaining agreement. one of the aspects that is unrelated, it could be related to a collective bargaining agreement, but more generally is going to apply to employers, is an employer cannot compel an employee to exhaust rights to any sick, vacation, or personal time prior to or while taking leave. So a lot of times we have language that says employers must use any paid time concurrently with their FMLA time. For unpaid FMLA leave that the employee may have previously otherwise been entitled to. Now employees would be able to stack the paid family medical leave and then any paid leave, otherwise paid leave that's provided. The question is, does that leave run concurrently with FMLA and the Maine Leave Act? Yes, they wouldn't stack. So leave taken under the subchapter does run concurrently with federal FMLA leave. So those kind of are how it interrelates with other statutes. As it relates to funding, which is a question we've been getting a lot of, this is where kind of the language Peter just mentioned about it applies to everyone. It doesn't matter how many employees you have. The only aspect of this bill that relates to how many employees you have or that matters is as it relates to funding. So specifically, beginning January 1st, 2025, the premium amounts can't be more than a combined rate of 1% of wages. Now, as it relates to that 1%, so each employer would have to take 1% of wages, could be less than, but I would presume will be right around 1% of wages, and would remit that payment to the state. If you have 15 or more employees, the employer can require that the employee pays 50% or 0.5% of wages, and then the employer will pay the other 0.5% of wages. And then if the employer has fewer than 15 employees, then the employer isn't required to pay the employer portion. They would just deduct 50% of the premium and remit the 50% of the premiums and wouldn't submit the other 50%. So they wouldn't submit a full 100% of the premium, only 50% of the premium. Peter,
Tawny?
I know, I was going to turn it over to you because I know that there was a lot going on here with the funding.
Yeah, so maybe I can make I can simplify this. The total premium amount estimated by Fiscal and Program Review to fund this program is $360 million. So that's the 1% that's going to be collected by the state. Dividing that in half, that's 130 out of the employer's pocket, and 160 out of the employer's pocket, and 160 out of the employee's pocket, and 180, excuse me. But here's the problem. The decision was made to exclude small businesses from paying the premium. So they won't pay their share of the 180 that comes out of the employer's pocket. All that really means, though, is that portion of their premium is being subsidized by the employers with more than 15 employees. And there are problems with that. And I think there will continue to be problems because it encourages adverse selection. Larger employers who have the ability, providing how they determine what constitutes substantially equivalent, could buy substantially equivalent plans on the private market, have greater control over the use of leave, and not pay into the state. That shrinks the premium base for everybody else and makes it harder to pay benefits going forward. It also discourages an employer from hiring that 15th employee, because remember, it doesn't matter if they're part-time or not, it counts because they're eligible. So there's a built-in incentive to keep your employment base at 14 and never go to 15, or definitely never go to 16. And that's, I mean, obviously that's unfortunate, but it means that, and the reason is because you're not paying the premium on one employee, you're paying it on all 16 of them. And if it was just the one person, it would be different. So that's the funding issue is a big one. We're out of step with the rest of New England. Massachusetts, Connecticut, Rhode Island, New Hampshire, Vermont don't require employers to pay anything. We have one of the highest premium base for employers in the country. And remember, there are only 13 states that have enacted paid family medical leave on their own. And Tawny, if I can go back to the benefits issue for just a minute, because there is one important point. And I don't know if you're going to get to the eligibility parts later on, but I wanted to be clear about something because I did talk to the Commissioner of Labor last night and we had a conversation about some of this. There is a requirement that in order to get job protection under this, that you work for an employer for 120 days. If you take paid family medical leave inside that 120-day window, you don't necessarily have your job protection. The employer could hold the job for you, but they could also permanently replace you while you are out. But here's the problem. If you permanently replace that person, you must continue under the law to pay their benefits, their full benefits, the amount of time they're out on the leave. There is no language in this that clears up that ambiguity. And at the same time, you're paying the full benefit load for the replacement worker. So you're essentially paying double benefits for 12 weeks while that person's out.
No, thank you, Peter. And let's actually jump to that next slide. And I recognize that we are already over. So we're going to kind of fly through this with the understanding everyone's going to get copies of the slides. The slides do have more information than we normally provide. So hopefully that'll be helpful. One of the questions we got was, does the 50%, how's the 50% to the employee calculated? Is it a base rate or is it based off of each individual's wages, and it's each individual's wages, so 50% of 1% of each individual. During that period of leave, they're going to be paid by the state pursuant to kind of this formula that's up on the screen with a maximum benefit amount that'll be calculated annually by the Department of Labor. One of the things that currently is concerning and that we're going to be waiting to see if the Department of Labor is able to clarify at all is intermittent leave currently indicates that intermittent leave can be taken and is permissible, but it can only be taken in increments of not less than 8 hours. The problem with that is if an individual qualifies for intermittent leave under federal law or under state law, that's at 15-minute increments. So right now, paid leave is being said you can't take it in increments of less than 8 hours, but under federal law, you permissibly can take it in much smaller hours. So we're going to have to get a better understanding from the Department of Labor as to how they're going to marry those two provisions. And then like Peter said, the prohibits retaliation. So there had been a hardship exemption in previous drafts. That language has been excluded. If the individual is employed for at least 120 days, and they must be restored to the same position at the end of their paid family medical leave.
Hey, Tawny, can I speak for a minute about the hardship exemption for a moment?
Yes, absolutely.
This is important. There actually is a hardship exemption language in the statute, but it's meaningless. I just want to be clear about that. And a lot has been made in the press about there's a escape hatch for businesses based on hardship. There is not. To be clear, an employee who comes to you and says, I need to take paid family medical leave, and they're a critical employee and you need them to stay, there is nothing you can do to compel them under this law to say, no, you cannot take that leave right now. People will say there is, but there isn't. The reality is the only hardship exemption for employers in this is the 120-day portion. In other words, you can replace that person if they've worked for you for less than 120 days. If that person has worked for you for more than 120 days, there's nothing you can do to stop that person from taking leave. And the reality is employers wouldn't do it anyway. But a lot of proponents of this bill have said, oh, we've helped small businesses out with this hardship exemption. Not true. It's not worth the paper it's written on.
With that, I mean, there's a lot to this bill. We're 5 minutes early. I want to skip, there's some slides here that everyone will receive concerning updates in Connecticut and New Hampshire. The one that we really want to draw employers' attention to is what's going on in Vermont, because there is fear that we're going to see very similar legislation to this in the coming legislative sessions. So I want to turn it over to Liz to just briefly discuss what's going on in Vermont.
Thanks. So Vermont has this session made a number of changes to their employment laws that really broaden employee protections. So one is that their pay discrimination law was amended to include not just race, but national origin, sexual orientation, gender identity, and disability. There's also a provision banning no rehire clauses in separation or severance agreements. So a clause that says you will not reapply, you cannot reapply to the organization, because you can't be hired by us, which is something, we often include in those agreements, are no longer permitted. The big change, though, that we want to flag is that Vermont has amended its statutes to essentially literally eliminate the requirement that harassment be severe and pervasive to be actionable. So the definition of harassment in Vermont, as it's amended to be, is unwelcome conduct based on an employee's protected trait that interferes with the employee's work or creates a work environment that is intimidating, hostile, or offensive. So the key words that are missing there that were there before are that there's a severe and pervasive level of harassment that makes it illegal harassment. The law specifically says that harassment need not be severe or pervasive to be unlawful. And it's, the new standard really looks at the totality of the circumstances. Employees don't need to compare themselves to other people in maintaining an action, but show that they're treated disparately compared to others. But this elimination of the severe and pervasive level for harassment to be actionable is significant because it's potentially, we're seeing it in other states as well, sort of loosening these definitions. But it's something that could potentially make its way a little further northeast. This has been a very pro-employee session overall. And I think, Peter would, I'm sure, be able to weigh in here, but I'm sure we'll continue to see a number of bills that are very pro-worker protection, which is fine. But this new standard really lowers the bar for an employee to make a claim. And it makes it more difficult for employers to judge and prevent behavior that might be actionable. So it'll be really interesting to see how this plays out, given that it's such a fact-intensive issue. And this is an entirely new standard under their existing law.
Yeah, no, thanks, Liz. I absolutely agree. I mean, the fact that there's not a comparator also is significantly concerning. And we talk a lot with employers about that when we have termination or disciplinary discussions. Peter, I know that there's a couple of bills that, are still in concept draft format that we could see next session. Well, this second session of this session of the 131st. Thoughts on this?
Yeah, I think Liz just said it. The attitude of the legislature overall when it came to workplace bills was, look, employees have the upper hand right now in the workplace because of the workforce shortages, et cetera, in a way that they've never had before. They're on a parity of negotiating, parity basis when negotiating, work terms and pay, et cetera, but it won't always be that way. So in order to make sure that workers are protected going forward, we need to pass these laws. So when the balance shifts, employees aren't at the mercy of employers, implying that employers are somehow mistreating their employees. That was said in the Labor Committee more than once in this legislative session. We showed you some bills earlier on that are carryovers. The Labor Committee and other committees could meet as early as this fall to start considering these carryover bills, many of which have not even had a public hearing yet. And their deadline to complete all carryover legislation and have it voted out is by the end of January. So we're entering into a fall where we already know we're going to be busy. I indicated I spoke with Commissioner Fortman last night. I asked her about rulemaking and what was going to happen with paid family medical leave going forward. She indicated that the department is not doing anything on that aspect of paid family medical leave until it becomes law at the end of October. They will start discussing rulemaking and what rulemaking will look like at that time. But she did indicate to me that by January, the intent is to have someone hired who will administer the paid family medical leave program in Maine, because they'll have the funding, and to appoint the governing board that will oversee the paid family medical leave fund going forward, all by January. So there will be some important things that happen early on in the legislative session around that. I really think there'll be a cleanup bill submitted next session around paid family medical leave. There was such a rush to enact this. It only had one work session by the committee. A lot was left undone, unsaid, and unclear. And it's a very complex piece of legislation that employers are going to have to figure out how they're going to live with and how they're going to manage in their workplaces.
Thanks, Peter. And thank you all. We apologize sincerely. We know we're 12 minutes early. There clearly was a lot to talk about. And if you have questions, we're available to stay a few more minutes and can answer those. Otherwise, thank you all for your attention and your time. And we look forward to seeing you at our next event. So thank you all.